Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard.
Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of Dakota is now in session.
Good afternoon. Please be seated. We are here at the time set for oral arguments in file 2025-0333, Lepird Drywall LLC, doing business as, is it Lepird? Lepird?
It's Lepird.
Lepird. Doing business as Lepird Decorating and Drywall versus Elite Flooring Installations, Inc., doing business as Team Elite Construction. Sitting this afternoon are Justices John Jensen, Justice Douglas Barr, and Mark Fries. Sitting in place of Justice Tufte, who is disqualified this afternoon, is District Judge Lindsay Newsoma, and we welcome Judge Newsoma to the bench. Arguing this afternoon for the appellant is Katrina Lang, and for the appellee, Mr. Timothy Hill. Ms. Lang, when you're ready, you may proceed.
May it please the court. Good afternoon, Your Honors. I'm Katrina Lang, and I'm here today representing Elite Flooring Installations, Inc. Counsel, I'll be referring to Elite Flooring Installations as Elite Flooring today. This case is about the liability of a contractor to pay for a subcontractor of a subcontractor, even when the second subcontractor was not hired by the contractor. Today I'm going to discuss three issues. The first is the lower court erred as a matter of law in finding Lepird satisfied the elements of unjust enrichment. Next, I will discuss why the lower court erred in finding an oral contract existed between Lepird Drywall and Elite Flooring, because there was no mutual understanding of the terms. Lastly, the lower court erred in dismissing Elite Flooring's conversion claim against Lepird Drywall. I ask you to reverse the lower court and find the elements of unjust enrichment were not met by Lepird, no oral contract existed between the parties, and Lepird converted the personal property of Elite Flooring. And I would ask you to award judgment to Elite on the conversion claim.
Ms. Lang, isn't the unjust enrichment claim a secondary claim that unless you prevail on the lack of contract, you don't even get to unjust enrichment, do you?
That's correct, Your Honor. So, to my first issue of unjust enrichment, this is an issue of law subject to de novo review on the entire record. Unjust enrichment requires 5 elements: an enrichment, an impoverishment, a connection between the two, an absence of the justification, and an absence of remedy provided by law. And Justice Barr, you hit the nail right on the head. There cannot be an unjust enrichment when there is a remedy provided by law. And that's when the impoverishment results from a valid contractual relationship made between the parties. That is, the result is not contrary to equity, and there can be no unjust enrichment. In this case, because there was a finding of an oral contract by the lower court between Lepird and Elite Flooring, unjust enrichment cannot exist as a matter of law, because the last element cannot be met.
I'm having trouble following this argument. So are you conceding there's a contract?
I'm not, Your Honor. I can jump to my breach of contract claim first, if that would be helpful to the court.
I think that would be helpful.
So in looking at whether or not an oral contract existed, that is a question of fact subject to the clearly erroneous standard of review. And here the judge has abused its discretion because it misinterpreted or misapplied the law. So the essential elements here require parties capable of contracting, the consent of the parties, a lawful object, and sufficient consideration. And the consent must be free, mutual, and communicated to each other. And most importantly, the offer and acceptance must assent to the same thing. If there is mutual acceptance, then we've got an obligation. But indefiniteness as to any essential term of the agreement will prevent the creation of an enforceable contract. And that's what happened here. This case is lacking the last element. Even the court stated this in its opinion at paragraph 11. Although the parties disagree about the terms of the arrangement, it is undisputed that Lepird performed the remaining punch list and patchwork tasks across the MAC, Taurus, and JP Place projects. So the court abused its discretion in relying on the secret intention of the parties. And that secret intention was Lepird believed that he was to be paid by the retainage on the property. He repeatedly testified that this was his understanding, and it shows a lack of mutual assent between the parties. The court also erred when it found
Is the manner of payment a material term in that contract?
it is. And I think when you look at what the judge looked at in coming to its conclusion, it cited that there were invoices between the parties. And while courts can look to invoicing and subsequent documents to determine an oral contract, here I'd advise the court to look at the Curtis construction case cited in my brief, where the court found that invoicing did not support finding of an oral contract. Like in this case, the invoices did not disclose Elite as a party. In the invoices sent that were produced at trial, Elite was not named as a party. The only invoice in which Elite was named as a party was the invoice that was attached to the second amended complaint, and that invoice was dated 4 months after the lawsuit was even served and brought. Next, they did not state any dates of performance or a schedule of prices. And let's say this court was going to look to the history between the parties, or the other thing that the lower court looked to, which I believe was an error of the law, an interpretation of the application of the law. It also looked to industry standard. And nowhere in the case law or statutory framework is there instruction for the court to look to industry standard. And so here, what the
Aren't industry standards a fact that the court can consider? If there was testimony about those standards, can't the court consider that testimony in reaching its factual findings?
So here, what the court should look to is the statutory direction and the case law that's already in front of it. Like, I think if the court were interpreting Article 2 under the UCC, there's a specific statute that references looking to industry standard to interpret a term of a contract. That's not present here. And if you actually look to, if this court is going to indulge that industry standard, what it will see, besides the testimony from Lepird, is that when Austin Erickson testified, he was a sub of Elite. He said they had agreed upon a price prior to Austin begin working. Also looking at invoicing provided by other parties, there was invoicing provided both by Juan Gonzalez, and which stated pricing, and invoicing, at least even via text message, provided by another sub that was hired by Team Elite that was presented as evidence. So we don't have any of that evidence here as evidence that was performed by by Lepird. Another fact that the court relied upon was its determination that Andy Rahman failed to disclaim responsibility on the JP Place project when Hammers Construction emailed Rahman a receipt of an invoice from Lepird. Again, this receipt was directed to Hammers Construction or CBE. It was not directed to Elite. And he says the email does not direct Lepird to pay. Rather, it states we have an obligation to get this guy paid. We have a responsibility to make sure he gets paid. For now, I will withhold this amount from your final billing. It doesn't say, Elite, you need to pay this bill or you're responsible. And then in a subsequent email to a project done by the same developer, CBE, Construction by Epic, Ramon actually does dispute it, and he said, my drywall contractor was one on this project. I've been told maybe CBE hired Lepird directly, so he in fact does dispute the work. Your Honors, I would ask you to reverse on the decision of finding an oral contract existed because there was no mutual agreement as to the terms of payment. And as I stated, because there was no terms on the final payment, their other alternative would be an unjust enrichment claim, but you can't have both. So with the lower court's finding of unjust enrichment and breach of oral contract, that's an error of law in and of itself. So in looking at the unjust enrichment claims, because there was a contract between Lepird and Juan Gonzalez, Lepird had a remedy at law to seek payment. He also had a remedy at law under the construction lien statutes. He could have filed a construction lien against these properties, against the building owners. In the case of DC Troutman versus Fargo Excavating, Royal Jewelers was not a party to that contract, but was an intended third-party beneficiary. This case is like that, in that there was a clear contract between the work that Juan Gonzalez did with its subcontractor, Lepird. So again, the contract is between those two. Lepird is simply looking for payment after Juan Gonzalez was no longer available. Elite was an intended third-party beneficiary of Lepird's work. Lepird knew that it was hired by Juan Gonzalez, who was subcontracted by Elite for the drywalling work and tape, texture, and painting. His performance was not an unjust enrichment to Elite. Rather, Elite was the intended third-party beneficiary. The Lockdown case is also another case this court could look to where the renter on the property had applied some chemical to the property and had been renting the property from an estate. The estate then put the property up for sale. The renter put in a bid, was not the high bidder on the property, so he sued the person who ended up being the high bidder on the property for unjust enrichment. Again, the court found he had, the renter had a direct lease agreement with the estate, so he had a contract with the estate. That's where he should go to for breach of contract, not the person that ultimately bought the property. So the court dismissed that claim and ultimately found in favor of the gentleman who purchased the property for damages against the renter for filing an improper lien. So similarly, because the court found Lockdown had an agreement concerning reimbursement with the estate, he had a legal remedy for the breach of contract. This was an adequate legal remedy which precluded Lockdown from pursuing an unjust enrichment claim against David Thompson, who purchased the property. Similarly, because Lepird had an agreement with Gonzalez and is also paid from the developers of the property, Lepird had an adequate legal remedy for breach of contract and cannot seek unjust enrichment from Elite, because the impoverishment resulted from a valid contractual arrangement. It was not contrary to equity. This court should find there was no benefit retained by Elite that would be inequitable. Elite got the benefit of its bargain from its contract with Juan Gonzalez. Lastly, I would like to briefly address the conversion claim. Conversion is the tortious detention or destruction of personal property or wrongful exercise or dominion of control over the property inconsistent or in defiance with the rights of the owner. The gist of the conversion is not acquiring the complainant's property, but in wrongfully depriving the complainant of the property. This court has said that a demand and a refusal are evidence of conversion, but are not necessary to constitute a conversion where the demand would be unavailing. In the case of Ritter, Labor and Associates versus Coke Oil, the court found that a demand would be unavailing because the oil had already been sold. And in the Burry versus Ramsey case, this court said it's of little relevance that the converter received no benefit from the deprivation. Conversion does not require bad intent on the part of the converter, only an intent to control or interfere with an owner's rights to use it to an actionable degree. And here, that's what we had. We had the court find that because there was no bad intent by Lepird, that there couldn't have been conversion. When in all actuality, it was completely uncontroverted that the paint supplies were removed from the job sites by Lepird and Austin Erickson. They both testified to that. The court acknowledged in its opinion, he said, Lepird candidly acknowledged removing certain leftover supplies at Gonzalez's direction. So there the court is looking to the bad intent and finding there's no bad intent. But in fact, the law states there's no requirement of finding, malfeasance or bad intent.
Ms. Lang, didn't the court also said there was never any request for it? And so I don't recall any finding that a request would have been unavailing.
So the evidence of the, so a couple of things here, Your Honor. First is that the request is unavailing. If the request is going to be unavailing, it's not required. Here, he had testified it was worthless. He had also stated that in the...
He meaning who?
I'm sorry, Lepird had stated the paint was worthless, and that was admitted by Lepird on the stand in the interrogatories that were admitted as evidence. He had stated the property was worthless. So like the Ritter versus Coke Oil case, if the demand is going to be unavailing, he had claimed it was worthless. What's the point in returning the supplies? But I would also argue that Andy Rahman of Elite really had demanded the supplies. In the text message that he sent to Lepird, he accuses him of stealing the paint supplies removed from the site. So if somebody accuses you of stealing, you would expect a response of, hey, I was instructed to remove that, I didn't steal them. There was no response in rebuttal to the allegation of stealing the supplies off the site.
How does your client come up with the value of the property that's alleged to be converted?
So the value was determined, he testified, and then
Your client testified?
Yes.
Okay.
My client testified that the approximate value was $20,000, and Ramiro Villarreal estimated, he was an employee of Elite. He testified that he believed the value was between $15,000 and $20,000, and they determined.
How do you get that from a few buckets of paint?
So this is
partially used.
So they had testified as to what they believed was removed from the sites, going back and comparing what was purchased by Juan under the account of Elite from Hirschfield's paint, and had estimated based on what they believed the amount of paint that should have been there and the amount of paint that they believe was taken.
But the testimony was the paint value was $85 to $120 a bucket.
That was the testimony provided by
And
Lepird.
what did your client say a bucket of paint cost? Presumably, these are 5-gallon buckets, not, a gallon, but in any event, is there some kind of commercial tank of paint or something? Because I just don't know how you can get up to tens of thousands of dollars from some buckets of paint.
So I think in looking at, there was also an affidavit submitted by my client in response, with respect to the motion for default judgment or motion for summary judgment about his estimated value. And then there was more than just paint taken. There was also some painting supplies, some mud, some drywall sheets that were testified that they believed were removed from the sites as well.
Those were not included in the original counterclaim, though, is that correct? That was limited to paint?
Yeah, what was alleged, may I briefly respond?
You can either use your time for rebuttal to answer the question, or you can answer the question when you come back on rebuttal.
Okay, I'll just answer briefly that it was just categorized as paint supplies in the counterclaim.
Thank you, Ms. Lang, and I should have asked you, do you go by Terman Lang or Lang? Because your brief says one thing and my sheet on the oral argument says
Your Honor,
just Lang.
even though I only practiced under the name Terman until I got married a year later, I still get called Terman a lot too, so I'll respond to any of them. Thank you very much.
Thank you. Mr. Hill, whenever you're ready.
May it please the court. Chief Justice, Justices, welcome. Counsel, good afternoon. I've known this attorney since she was a young child, and I worked for her father when I first started practicing. So we have a long-standing relationship. It is a privilege. I say it every time I come here. It is a privilege to stand here at this podium. And it's also a little scary. I've been practicing law for near 40 years. It's still a little scary to come and be up in front here. And I think anybody that says different would be wrong. As the court knows, I represent Isaac Lepird. I constantly call him Lepird, but it is Lepird. I even had to draw a picture of my version of a leopard so I'd remember it's Lepird. He's a drywaller.
Mr. Hill, let me ask some questions. I just want to make sure that factually I'm understanding this. Your client had a subcontract with Gonzalez, correct?
He did.
And
Gonzalez they're all drywallers.
Sure. Was anything on the punch list included between the agreement between Gonzalez and Lepird? So the $44,000 at issue here.
The punch list was there when Gonzalez left, if that's what you mean.
That's not my question. There's an agreement between Gonzalez and your client Lepird to do X work, correct?
Yeah, he was hired as a subcontractor for Gonzalez to do drywall.
My question is, any of that X amount of work that's under the agreement between Gonzalez and Lepird, is any of that included in the damage claim here?
No.
Okay, thank you.
I will tell the court that.
And the reason why I ask is it goes to the claim under unjust enrichment. Your client couldn't sue Gonzalez under that contract because those damages weren't included in that contract.
They were not.
They were outside of it.
They were. And the court has to understand there was a punch list items and there was patchwork.
And I seem like I'm yelling, but I know the last time you were here, you were having trouble hearing. So I'm just trying to be respectful and speak up.
I appreciate that.
Okay.
So, and I hope I don't misinterpret anything the court says because of my hearing issues. So there was also patchwork items, so the court's aware of that. It wasn't just the punch list items. Punch list items were the things that the owner goes through saying this has to be fixed, this has to be fixed. Patch list things were like change orders. Those are determined by industry standard. And in industry standard, I know one of the justices asked about industry standard, but what is done in the industry is respected and acknowledged and can be taken into account by this court. They do it all the time in products liability cases. Industry standard is what both Lepird and Andy Rahman, the owner of Elite, testified that, a lot of the oral contracts are done by oral agreement. Elite testified that all of his other subcontractors, there were many, all of his other subcontractors that he had to hire besides Lepird were all oral contracts. There weren't any written contracts. So where are we at? Lepird did a job. He was hired by Elite to finish the punch list items and to finish the patchwork items. He didn't do this gratis. He wanted to be paid. He fulfilled his promises, and there was no credible testimony of any deficiencies. That was one of the things that Elite argued at trial, is that, well, there were deficiencies, but the court found that there was no evidence that any of the work done by Lepird was deficient. So who are the sources of who could get paid, who would pay Lepird? Well, Andy Rahman of Elite testified, well, it should be Epic. Epic was the general contractor, they should pay. And their argument is, well, Epic paid Lepird for some work, Lepird should go back to Epic. And it's true that Lepird did do some separate work for Epic beyond what was contracted with Elite, but that was paid separately. It's not included in these punch list items or patchwork items. There was no other relationship with Epic other than that.
Was it at a separate job site? Was that the work done at a separate job site?
What'd you say?
Was that the work done at a?
Yeah, it was, and it was billed and paid. There's been numerous arguments about Juan Gonzalez that Lepird should go back to Gonzalez for payment. Well, it was abundant testimony in this case that Gonzalez left. He abandoned the site, he abandoned Lepird, he abandoned Elite, he left. There was ample testimony from Andy Rahman that Gonzalez was never coming back. He was leaving the country for personal reasons or some medical reasons or something. He wasn't coming back. And worst of all, Elite testified that they paid Gonzalez the 10% retainage that was supposed to go to the punch list items, knowing that these items weren't completed. There's no reason either under an unjust enrichment claim or any other argument that Epic or that Lepird should go back to Gonzalez for payment. I mean, heck, Elite brought a third-party claim against Gonzalez, but they had to drop it. And why? Because they couldn't even serve him. They couldn't even find him. There was no way that Epic or that Lepird was going to get any payment from Gonzalez.
But that's not really relevant, whether they would get it from him. If either they have the legal ability to go against him.
What, sir?
Either they have the legal ability to go against him or they don't. It depends who the contract is with. It really doesn't matter if he's judgment-proof or if he's unservable.
Yeah, and you're right. And there was no legal ability to go after him because Lepird didn't contract with Gonzalez to do the punch list items or to do the patchwork. He contracted with Andy Rahman, and he testified that he had phone communications with Andy Rahman of Epic to do that work. And there was testimony that Andy Rahman was at the site. He saw Lepird doing the work. He saw that Gonzalez wasn't there. He knew more about what happened to Gonzalez than Lepird ever did. Most of what was discovered about what happened to Gonzalez was learned by Lepird at trial. We believe that this court correctly found that the responsible party was Elite, and the trial court concluded that Elite should pay for the work that was done by Lepird. And we're asking this court to affirm that agreement. As far as the contract goes, we think there was offer acceptance. We think there was consideration. There was definitely performance. When Gonzalez left, the work had to be done. Lepird testified that he went to Andy Rahman and said, I'll do the punch list items, I'll do the patchwork items based on the 10% retainage, based upon industry standards for patchwork. That's what he did.
Was there any evidence that any of the work began before that phone conversation occurred?
Of the punch list items?
Correct.
No. No. And we do know that the only person left standing when Gonzalez left was Lepird. And he went to communicate with Elite as far as, okay, well, I'm the only one here, I'll do the patch list and I'll do the punch list items, but it's going to be based on the retainage. And I've always had a problem with regard to the invoicing of this. There was an invoice submitted ultimately in this case for the amount owing, but I wonder if there even needed to be an invoice because the parties understood what the payment was going to be. It was going to be that 10% retainage. That's what they do. They retain the 10% specifically for punch list items. Of course, the only one that knew that the retainage had already been expended was Andy Rahman of Elite. Isaac Lepird didn't know that. He didn't know that it had been paid out. As far as patchwork items, the understanding is that you go by industry standards. Both parties acknowledge industry standards in the course of dealing and in trade practices. Both parties testified to that. There was testimony, or there was argument by counsel on this paragraph 11 of the judge's decision that although the parties disagreed about the terms of the arrangement, they didn't disagree. When he goes in to discuss the actual contract, he does specify that there were terms. I think that line was a misstatement because he does specifically examine what the terms were in his breach of contract argument as part of his order. And the terms were finish the patch list, finish the punch list, you'll get paid the retainage. That was the deal. The unjust enrichment claim, that was an alternative claim. It was addressed by the court. The court even says, I'm awarding based upon contract, but I'm going to address the companion claim of unjust enrichment. It is our position there wasn't enrichment, there wasn't impoverishment, there was an absence of other remedy. Was Elite benefited by the work? Of course they were. They have to answer to the general contractor and to the owners of the property. They got fulfillment of the work that they were hired to do as the subcontractor for drywalling. It had to turn to Lepird to do the drywalling because Elite didn't have the staff to do it, so they turned to Lepird to finish it up.
Mr. Hill, is there any legal error by a court making an alternative finding to avoid a remand if an issue is appealed?
I don't think so. I mean, as far as legal authority, I'm unaware of the authority on that, but I think that the court addressing it and setting out in his decision that I'm not awarding it based upon unjust enrichment, but as an alternative claim, unjust enrichment would stand. I have no belief that our judge in this trial case did this to avoid an appeal, but I think it became such an issue at trial that the judge had to address it as part of his decision. There was an impoverishment. My client didn't get paid a dime, and I believe there's still an absence of any other remedy. There wasn't a contract between him and Gonzalez to do this when Gonzalez left, and there would be no ability for him to secure payment.
What about Ms. Lang's argument related to filing a lien? What about the argument that there could be a lien on the property as a remedy?
A lien on the property? As far as a lien on the property, he didn't really have a claim against the property owners or the general contractor. His position in this case is that the remedy he had was against the person that hired him, which would have been Elite. That's our position. And there was no testimony taken by anybody of putting a lien on the property. Unless the court has a question about the amending of the complaint, I won't address that. Counsel didn't address that. I will point out, though, as far as the timeline for amending the complaint for unjust enrichment, this complaint was filed in June of 2024. Motion for summary judgment was brought the next day, June 14th of 24. There'd been no discovery. There wasn't even a scheduling order issued until July of 24. The scheduling order provided that discovery could be served through November 15 of 2024. The order granting the second amended complaint for unjust enrichment was signed on October 4, 2024. I say this because there's an argument that there should be an increased substantial proof argument because it was a summary judgment motion. And my position is based on justice alone that this summary judgment motion was brought prematurely early in this case, days after the complaint was filed. And there was no discovery, there was no exhaustion of any of the resources or actions that could be taken in the case that would warrant a substantial proof element for amending the complaint for unjust enrichment. As far as the conversion argument, you know, in any project when a sub finishes a job, there's cleanup. You know, you want to get the property in a position that the owners know that it's ready for sale or marketing or whatever they want. They don't want a whole bunch of junk sitting around any of the remaining materials. There was an ample testimony in this case that there was no documentary evidence establishing any of the lost product as far as any of the valuation. There was no documentation saying what was the value. There was testimony that if there was $20,000 or $30,000 of paint loss and other incidental supplies, and there was like a box of stuff that was taken out other than the paint, there was testimony that this would have been a truckload of paint. If it would have been that much paint, it would have been a truckload. And it wasn't. It was a small amount of paint, not usable on any other projects, not used by Lepird on any of his other projects. Most of it's gone stale. There was no demand for return of it. There was always an opportunity to retrieve the property, but it's useless. There was no persuasive testimony of what really was taken other than I want my materials back. There was no testimony saying this or that needs to be returned to the property. Based upon that, the conversion claim should not stand. We're asking the court to affirm the findings in the judgment of the lower court in this case. And I appreciate the argument. Unless there's any other questions, I'm concluded with my argument.
Seeing none, thank you, Mr. Hill.
Thank you.
Ms. Chairman Lang, you have, looks like 10 minutes for rebuttal.
Thank you. All right, in response to the conversion claim regarding the value of whether or not there was a demand and the value. So again, one of the elements is whether a demand would even be availing. And in the answer of Lepird, it was alleged that the paint was worthless. And then again, in interrogatories that were admitted as evidence, it was inquired as to the basis for the statement that the paint was worthless. And he says there are only a couple of buckets, mostly partial buckets. Superintendent demanded they be removed. The next best place was the garbage. So clearly there was no, the availing, he had claimed that they were worthless. And again, the response to that is if you look at the pictures of evidence, and there were videos admitted as evidence as well of the paint at the shop, if it was indeed worthless, why did he take it to his shop? I believe the evidence.
But isn't the question about whether it would be unavailing is that if your client had asked for it, it wouldn't have been given back? Doesn't your client have to ask to argue that it's, to seek it would be unavailing?
Well, to say, he did send the text message that you stole this from the job sites. So, to say give it back after you've accused somebody of stealing, I feel like that is enough to make the accusation that you took something wrongfully, and he's alleged that it was worthless. So while he didn't specifically state, please return them.
You're viewing that as a denial of returning the thing of value that your client thought there was there.
Yes. And he stated that it was worthless. Well, if it was worthless, why didn't he throw it away? Why did he take it back to his shop? And why wouldn't he say, come and get it? It's worthless, or, make it available to my client.
And I trust these were all factual arguments you made to the court.
Correct, Your Honor.
And as finder of fact, it rejected those arguments, or at least that there was insufficient evidence to show there was any value.
Right, but if you look at the application of the law, it's my position that the demand was made, number one, and then number two, that he had alleged it was worthless. So looking at the Ritter case, there's really no reason that the demand even has to be made. Next, with respect to the elements of contract, I think it remains disputed as to punch list and patchwork. Those were two separate items under the contract, whereas punch list items were to be included, patchwork items were not. So patchwork would be change orders that would be billed directly and not included in the contractual price that Gonzalez had agreed to do as part of the overall work. And I don't believe it's disputed that Andy Rahman told Lepird that he was not paying, he had not been paid, he was not paying for any of that work. So again, this goes back to what is included as alleged in this contract. If you look at the third element, we don't know if patchwork and punch list is included. They're alleging it is all included. My client disputed that. And secondly, as Mr. Hill said, the only one that knew that Andy, his client's position is that only Andy Rahman knew that Juan had been paid. Again, this shows that there was no mutual understanding of what the terms of the agreement were. And, the testimony is repeatedly from Mr. Lepird that he had this understanding of that there was retainage on the project. He states, did you understand there was retainage on the bid price? Yes. Okay, and there was 10% retainage on each of these projects, from my understanding, yes. It's not from what Andy Rahman told me, it's from his understanding what he believed was there. So Your Honors, if there's no additional questions, I would ask you to reverse the findings of the lower court on the issue of contract and conversion, and find as a matter of law that the elements of unjust enrichment were not met. Thank you.
Ms. Chairman Lang, thank you for your arguments this afternoon, and Mr. Hill for yours as well. This case will be taken under advisement, as all cases are, and our court will be adjourned until 2:00 p.m. on Friday, May 1st, 2026.